All rise. The Court of Appeals Division 1 is now in session.
Be seated, thank you. Now is the time set for oral argument in cause number 1CA SA 18-0169. Jennifer Jones versus the Honorable Arthur Anderson and the Honorable Karen O'Connor, etc. For everybody's information, these proceedings are being both audio and video recorded, so barring any unforeseen problems, it will be on YouTube, good or bad, in a couple of weeks. Counsel, each side will be entitled to 20 minutes, and we would ask that you respect that time period. The timer located on the podium will let you know how much time you have left, and for the appellant's benefit, if you wish to reserve any portion of that time for rebuttal, please let us know. We will try our best to keep from taking up all of your time. Ultimately, however, it is your responsibility to save that time. We have reviewed the briefs. We've conferenced the case this morning, so we are well aware of the facts and issues attendant to this argument. You might want to keep that in mind in addressing the court this morning. Counsel, and for each side, and we're going to get to a minute here in a minute as to who's going to be speaking on behalf of. When you come to the podium, I would ask that you state your name and who you represent. And that all having been said, from the appellant's perspective, Mr. Horn, are you going to be the? I saw a note here that was left for me. You're going to be using the time.
I am, Your Honor.
Okay, thank you. And for the appellees?
I will be, Your Honor.
Okay, and you are?
I'm Bob Williams from the Attorney General's office.
Thank you. Thank you. Do we have any other pre-business? Mr. Horn, it's your podium.
Mr. Chief Judge, and may it please the Court, we would like to reserve 10 minutes for rebuttal, if possible, Your Honor. Your Honors, I would like to begin my argument with two very contrasting quotations. The first is from John Kennedy, that race plays no proper part in American life or law. The second, very contrasting quote, comes from the case manager in this case, who said, "Brown babies don't stay with white mamas." We are dealing here with the frightening possibility that children were taken from the person with whom they bonded during their early years, almost 2 years of their early lives, because she was the wrong race.
Counsel, are you suggesting that we need to address this primarily as a race violation issue, a constitutional infringement?
It plays a prominent role, Your Honor.
That's not my question. I mean, when we get down to it, are we talking about violation of statutes and rules, or are we talking about a race-based decision that would violate constitutional law?
Your Honor, we're talking about overturning two decisions, one of which was to deny our right to intervene, or to deny our motion to intervene in the case, and the importance of that in bringing to the attention of the court all of the relevant information that was necessary for the welfare of the child rests on the race-based part. But the decision itself that we're asking for is overturning the decision to deny the intervention of my client.
Well, there's nothing in Judge Anderson's order that would indicate it was based on race.
Your Honor, the motion that changed the placement was a short, less than two-page motion with a 1.5-page attachment, and that attachment was the.
But you haven't petitioned this court to review the placement order. You've asked this court to review the intervention orders.
That's correct, Your Honor.
And my question to you is, there's nothing in those intervention orders that would indicate that Judge Anderson had considered race, is there?
That's correct, Your Honor. Not in the order itself, but in the motion that sought to move the placement.
Again, you haven't petitioned for us to review.
That's correct, Your Honor.
Okay.
We're asking to review. I just want to mention this one thing because the department denied that she had said that, and at the DCS Appendix 20 is the report by Crystal Tate, the person who we say said that, and in that report she says, ethnically, culturally, and racially, paternal aunt can provide the children with a connection of their racial makeup. And that played a very prominent role in the argument presented to the judge. A short 2-page motion, a short basically one-page report had that argument in it. So it played a very prominent role, even though it's not stated in the order itself.
Well, we don't even know if the judge considered that in making his determination.
I understand, Your Honor. But then the question becomes, if DCS denied that it was said, what chance did we have to get the judge to know whether or not that did play a role? And the problem is that by denying the motion to intervene, which is one of our two principal issues, the trial court prevented any determination as to conflicting views. So all the trial court could do is accept DCS's denial on face value.
Don't you want to? I'm interested in knowing about the safety issues that your clients seem to be raising in this spring and late spring that otherwise would not have been raised or weren't being raised. Is that the case? So
Yes, that's correct, Your Honor. There's at pages, I think, 11 to 15 of our petition, there are very substantial problems with the aunt herself, but the biggest problem was with her brother, who was living with her, who had convictions on guns and drug charges, who the child came home, and this is what started the biggest concern on the part of Jennifer Jones, my client. The child came home and said that she had problems in her vagina and that she'd been hurt by the stranger at the aunt's house where she'd gone for visitation.
So
and
those were the issues that your client sought to raise as an intervener. Would she have been able to raise, was she able to file any sort of objection to placement or safety concern issues in court as a participant during the 6-month window?
She was not, Your Honor, and that's fundamental to our case. And in that, we agree with DCS on a lot of the answers to the questions this court had raised in their list of questions, which answers are in my reply. We agree with them. As a mere participant, we had no right to do almost anything. We had no right to call witnesses or to do. We had no right to notices. And of course, that's made much worse by the second order that I'm going to talk about. But one of the interesting things that happened in this case is that DCS referred to a minute entry of the court because it thought it benefited them before this court, and they said we can't attach the minute entry because the judge has ordered that Jennifer Jones can't have any knowledge at all about anything that's going on. She didn't even know that the hearing was being conducted.
Before you get to your second issue, will you just let us know, has your client filed a petition to adopt?
We have not, Your Honor, because that can't be done until termination occurs. And at the moment, we have no way of knowing whether termination occurs or not because we're walled away from any information at all. But if we could have that information, we would file a petition to adopt, Your Honor. So just to tie up the summary, and then I'll get into more detail on this one so I can get to the second one. Basically what happened is contrary to our adversary system. We couldn't bring these concerns to the court. We couldn't argue with these things. And the court was deprived of vital information about the safety of the child, as Your Honor points out, and a lot of other problems with the interests of the child because the court refused to let her do anything. He basically walled her out. Even before that, he kept interrupting her and saying, I don't want to hear from you, even before he barred her from his court.
What's the answer to the proposition that, well, the judge did consider the Bechtel factors even though he didn't expressly say so?
Your Honor, I think the most important Bechtel factor for these purposes is, will the party bring information to the attention of the court that it would not otherwise get in determining the best interests of the child? And that he did everything he could to exclude her from presenting vital information that he had to have to make a proper decision as to the best interest of the child. The second issue is that there should be a reversal of the July 2nd order, which is obtained by an ex parte communication between a lawyer and a judge. We have shown that it was ex parte communication with false facts. The only thing the court has before it, any place in the record, are declarations under oath that show that my client did not disclose anything to her investigator that came from DCS information. And that is the only information in this record about the facts. But the important thing is that there should, I would think, the most fundamental thing about our system of law and of ethics is that a lawyer does not engage in ex parte communications with the judge and then try to take advantage of an ex parte order. Now,
And Mr. Horn, I don't disagree that those are standard principles, but let me ask you a question. If you win on the first issue,
yes.
do we need to take any action on the second issue? I mean, if the judge is now reconsidering the motion to intervene, if you become a party, then doesn't that moot out the issue of whether or not you disclose confidential information?
It moots the issue of whether she can be barred from his courtroom, I suppose, although presumably even as a party he might feel he has the authority to do that. He felt he had the authority to do that as a participant. But I think it's important, but it doesn't moot out the fact he referred my client for criminal prosecution based on an ex parte communication, which was false, which all the evidence here shows that it was false, the communication was false. And he referred her lawyers, including myself, for criminal prosecution and for complaint to the state bar based on absolutely no evidence and without our ever having a chance to respond, again, based on an ex parte communication. I think if there's anything fundamental that this court should not tolerate, it's a final order based on an ex parte communication from a lawyer to a judge. And
But we can't really change those referrals. I mean, they've been made.
yes, but if
And those are independent bodies that can or will be responsible for their
yes,
own
Your Honor,
investigation.
but if the order is reversed, which I think it should be, not only because of the falseness, but simply because it was a result of an ex parte communication, that would certainly make a huge difference. And I think that just on the principle that you don't take advantage of an ex parte order, this calls out for a reversal, Your Honor. They say it was a result of a mistake. I think it's an interesting mistake where the motion was directed against us and we were the only one of 5 lawyers on the list that didn't get a copy. But let's assume it was a mistake. If I had made a mistake like that, I would have been devastated that happened. I would immediately call the other side, apologize, and say, let's reopen it and you can do a response and then we'll have the judge decide. I got no such offer from them. They knew about this the day that I filed my supplement to the special action, which is a long time ago now. They made no attempt to contact me, and when I contacted them and said, are you willing to reopen it, they said no. They want to take advantage of an order they obtained by an ex parte communication to a judge. To me, that's unbelievably outrageous. And I think it really calls for an order from this court saying, try again. You can file your motion again, but this time let the other side be heard. Now, with respect to the motion to intervene, I see I only have 8 minutes left. Should I save time for rebuttal?
That's your call.
Yes, thank you, Your Honor.
Counsel?
May it please the court, my name is Dawn Williams and I represent the Department of Child Safety. Also present are Rob Rosanelli for the children and Chris Stavros for the father.
Counsel, can I start with a question just to hopefully exclude an area?
Absolutely.
Have you defended against a racism or a racial cause of action in this case?
No, not at all. And the reason for that is that one caseworker's statements don't demonstrate a racial bias in this placement. The placement change was made by the juvenile court judge. The decision was made by the department as a whole. One caseworker doesn't make those type of decisions. And the report from which Mr. Horn quoted also indicated that the purpose of placing the children, the priority, as the report said, was placing the children with families so they could maintain their extended family connections.
Ms. Williams, I have a question for you. Has the father's rights been severed?
Your Honor, I'm not really sure how to address that because of the
yes or no answer would be
confidentiality.
appropriate.
Well, there's the confidentiality issue. So there was a hearing on Friday. If the court wishes, I can provide an answer, but
I wouldn't have wanted to know if I hadn't asked the question.
I just want to be sure I'm not violating the statute. Yes, father's rights were terminated on Friday.
Okay.
So
And as
par-
have mothers.
mother's rights were terminated some time ago.
Okay.
Yes. So both parents' rights have been terminated. The children are free for adoption at this point.
Okay.
And I would note that the petitioner here hasn't provided any support for the notion that the parents' rights had to be terminated before an adoption petition could be filed. Often in private adoptions, the termination is part of the adoption proceeding when a parent is typically relinquishing their child for adoption. So I don't know that argument holds water, that she couldn't have pursued anything. In addition, she could have filed under ARS 8807K for release of that information for a specifically narrow piece of information. Have the rights of the parents been terminated so that I may file an adoption petition? The juvenile court could have weighed the parties' interest in that and decided whether or not to release that information. So there are plenty of other avenues other than intervening in the children's dependency proceeding by which she could have gotten the information that she wanted in order to pursue an adoption.
So I appreciated the detailed explanation of how the various statutes relate to each other post severance, and I understand that the parties who want to adopt may do so by filing or may attempt to do so by filing a petition or motion for adoption, and in a case where there are competing potential parents, each files a separate case, initiates a separate case. Are those likely to be consolidated? Is that the normal situation?
To be honest, it's not a normal situation that we have competing adoptions. Usually once the juvenile court has made a determination in the dependency action about the most appropriate placement, that placement is the one that seeks adoption. It does happen on occasion, and it's up to the juvenile court and the parties whether they file a motion to decide if those will be consolidated or not.
Although I understood your brief to say that if Ms. Jones files a motion to adopt, she will remain ignorant of whether anyone else has filed a motion to adopt.
Correct. And just to be clear, adoptions can only be done by petition, not by motion.
I'm sorry.
So I understand it, but it is confusing.
I fundamentally understand the difference between
I know that, Your Honor. I just wanted to make the record clear. But so yes, if she files a petition to adopt and so does one of the children's family members, then they will not have knowledge of each other's actions. Likewise, the department would have knowledge because the department is a necessary party in any adoption action for these children as their legal caretaker. But
so DCS and the court would have knowledge,
correct.
but not the individual parties necessarily.
Correct. And because of the issues at stake in this case, the department, as soon as it became aware of competing adoption petitions, would advise the court. And typically what would happen is that those matters would be consolidated before the judge that handled the dependency matter, which would be Judge Anderson in this case.
So at that point, then, they move forward as a single cause of action,
If the court consolidates them, yes.
so that the pleading parties, the requesting parties, would all know and be able to not only present their case, but contest the other person's legitimacy, let's say, as an adopting parent.
Correct.
Okay.
But as we noted in our brief, there is no discovery process in an adoption. There would be disclosure of the adoption home study that's done, but that would really be the only evidence that would be available in an adoption proceeding rather than a civil proceeding where you would have the full panoply of discovery where Ms. Jones could perhaps find the information she seeks regarding the aunt and her living situation or the grandmother.
Are the parties able to call witnesses and cross-examine?
Yes. Typically, the only witness is the caseworker in the case of a DCS-initiated adoption, and the adopting individual is always a witness to testify that they do intend to adopt the children. But they could conceivably call other witnesses if necessary.
So the multiple petitioner situation would give rise to more contest, if you will, because the one would be saying what they're saying I don't agree with, or I believe not to be a true statement of the circumstances, and the other way around, correct? So it would become a much more contested proceeding.
Definitely, yes,
All right.
yes. And I disagree with,
Oh,
I'm sorry.
Before you move on from
Yes.
that, so the home study that the department does, I'm assuming that they do a home study for both petitioning parents, and would those home studies be made available to the other?
If the matters were consolidated, they would. So if,
But if they weren't, so if they weren't consolidated, Ms. Jones would not have access to the home study of the aunt or the grandmother, and
Correct.
vice versa.
correct, correct. And I'm actually not sure if the department would do the home study for Ms. Jones. She may have to contract privately to do that, since the department is supporting adoption with a relative.
So they wouldn't do a their
I'm
own
not
home
sure.
study.
To be honest, I'm not sure, Your Honor. The department typically only does, like I said, one home study in these cases, so I'm not sure how that would play out.
It would certainly seem to leave the trial court in the dark, wouldn't it? As to
Well,
when-
a home
as-
study is
hang on,
required.
hang on.
I'm sorry.
As to whom, is it who or whom, was the better of the two applicants, the two petitioners, the stronger petitioner for the care of the child?
The
Adoption.
The adoption requires a home study. The question is just whether DCS would produce that home study, or if Ms. Jones would have to privately contract for it. So the court would have a home study no matter what. If the matters are not consolidated, it may not be before the same court. I think the juvenile court would be likely, because it would involve the same children. They have a one family, one judge policy, so both adoption matters would be assigned to Judge Anderson. If Ms. Jones were again to file a notice of change of judge, I'm not sure what would happen in terms of consolidating.
Well, if they don't consolidate them, then you could have the adoption granted by the two judges to two different parties.
Well, that's why the department would notify both courts of the pending actions, and the courts would have to communicate, because we wouldn't want two competing adoptions. That would be chaos.
That would be bad.
That would be really bad.
Can we talk about the motion to intervene
Absolutely.
and the ruling? And let's talk about the first, if we could talk about the first ruling. When Judge Anderson denied the first ruling, he said it was something to, I'm paraphrasing, it would be inappropriate. And then he said Ms. Jones has rights under 847B. How does that indicate to us that he's considered the Bechdel factors?
Well, primarily, the reason for that right of participation for foster parents is that they're able to provide information to the court that may be necessary regarding the children's best interests and care. The department has always acknowledged that Ms. Jones knew these children intimately. She was an incredible foster mother for them and did a wonderful job. And to be honest, I don't know how foster parents do it, how they can love these children and then be asked to give them up. I understand that that's very hard. But in this case, she had that ongoing ability and opportunity to provide that information. And she did in this case. She provided the information from her private investigation and from her own concerns to both the department and the court. She made hotline reports, as she's required to do, and the department fully investigated all of those concerns and presented that information to the juvenile court. So all of the information she sought to present to the court was before the court without requiring her to be a party. So I think that's what the court was getting at, is that the court had the ability to get her insight and her knowledge about the children and about the circumstances surrounding their placement without making her a party.
But didn't Bechdel talk about the fact that those factors need to be addressed on the record so that a reviewing court can determine that they have been considered?
It did in terms of a relative intervener. It didn't specify with respect to a foster parent. That was addressed by the Roberto F. Court, which found that if the record implicitly supports those Bechdel findings, that's enough.
Well, but there's a distinction between those two cases, isn't there? Because Roberto F., the intervention had been granted, when in Bechdel it was denied.
That's true.
And doesn't it make a difference?
It could, certainly. I think that the fact of the matter is the record was pretty clear here in that the parties briefed the Bechdel factors and presented that information to the court. So this court can see what the court reviewed in terms of those factors and how that played into the court's ultimate determination.
Well, Ms. Williams, if you could take one step further. If we were to hold that, in fact, in ruling on a motion to intervene, in denying a motion to intervene, you don't need to go through the Bechdel factors. Wouldn't we be telling the Arizona Supreme Court they were wrong when they say you have to go through the Bechdel these factors?
I don't believe so. I mean, if you look at Bechtel itself, it says that the court may and should consider those factors. The only mandatory factor is that the court consider the children's best interest. And so, again, I would point out that the Supreme Court did limit it to grandparents and other close relatives. So I think the fact that the Supreme Court, which also reviewed the Roberto F. decision, albeit on another issue, is aware of that decision and is aware of the distinction and didn't overrule it. So I don't think that we'd be telling the court that they were wrong. I think you would just be acknowledging that there's a difference in status between a family member who's seeking to intervene and someone who is a legal stranger to the children.
Isn't there another interpretation of Judge Anderson's sparse ruling, which is to say that a foster parent, because she has the rights of a participant under 847, is effectively an intervener already, so why need we bother? And that's not true, as the briefs point out, and you do a very good job of doing that. They aren't equivalent. There's the 6-month period of availability, which now has expired to begin with, and they're just not equivalent otherwise.
That's correct. They are two very different schemes. The right to participate is very limited. It's limited to dependency review hearings only. And even if the court's ruling was just shy of 6 months in this case, Ms. Jones wasn't precluded from participating in any review hearings, and that's the only thing she had a right to participate in. And so it is a very different type of issue, but I think what the juvenile court, what Judge Anderson was saying, is that he had heard Ms. Jones's concerns, and that was really the only reason for her intervention is to contest placement, and he had already heard that information and made a decision about it. And so by the time she moved to intervene, that decision had already been made. She was seeking to relitigate that position. She didn't move to intervene before that placement determination was made. It wasn't until not only after the determination was made, but after the placement was completed, and which took a matter of several months. So I think the court was saying, I've already heard her concerns. They've been addressed. We're moving on.
Are you talking about the second motion, the second time he denied the motion to intervene?
Right.
But in the first one, it does appear, as Judge Johnson mentioned, is that he was denying it because she had a right to participate.
He did note her right to participate, yes, but as I'm saying, I think that was his acknowledgement of the fact that she had provided information and could continue to provide information for 6 months regarding her view of the children's care and what was in their best interest. But ultimately, he had appointed a guardian ad litem to assert their best interest, and their guardian ad litem agreed with the change in placement. Not initially, but after she raised her concerns and they were addressed. The guardian ad litem determined that that was the most appropriate placement for the children and advocated for that placement.
From the record that's available to us, we don't, or I don't see that the safety issues that were identified in the investigator's affidavit that I think was filed with the supplemental or renewed motion. Mm-hmm. I don't see those being addressed anywhere. Did the court address those in any proceeding?
It did in several proceedings. I'm not sure that that was part of the record that was presented in the special action, but I think there was reference to the fact that the aunt completed drug testing and it was clean, addressing those concerns, and that the home study had revealed that the uncle did not reside in the home. So I think those elements are in the record before the court, but I do know that the court did address those concerns on at least 2 different occasions.
What about the concern of the children maybe being left unattended in the middle of the night?
And again, I don't have those portions of the record, so I'm not sure exactly how that was addressed. I would note that the fact that someone rang the doorbell in the middle of the night and no one answered isn't proof that the children were home alone. It's proof that someone didn't want to answer the door in the middle of the night. I know I often don't answer the door if it's late at night. So I think the fact that this is proof that the children were left alone is a little bit of a stretch.
It does present a colorable claim, doesn't it?
Certainly, and that's why Ms. Jones, as a mandatory reporter, reported that to the hotline, and DCS investigated and determined that the children were in a safe and appropriate placement with their aunt. She was
But
a
the
licensed.
trial court didn't resolve any.
The trial court did. The trial court maintained the placement after those issues were raised and addressed.
So it's sort of a de facto addressing of it. The court's leaning this way anyway, and he didn't see enough to change his direction.
The court has an obligation to order the children removed from an unsafe placement, and the court never ordered the children removed from the aunt's placement. So the court did address those concerns and did not order a removal. So I think on that basis, and again, as I say, I don't have that information. I didn't review transcripts of those particular hearings, so I can't speak to that in any more detail.
Counsel, you will agree there's a big difference between someone who's allowed to file pleadings and take an active part in litigation and someone who's allowed to be there in case there are any questions they need to answer.
Absolutely. It's a very big difference. And that's, I think, the heart of what we're arguing about here is that the aunt hasn't demonstrated that she had a right to that bigger role of an active party in these proceedings.
You said aunt, but you meant Mr.
I'm sorry, Ms. Jones, correct. And so because all she demonstrated is that she wants to be a permanent placement for these children, that's wonderful that she wants to do that, but that's not an issue that the court needs to address any further.
But if she found fault with DCS's representation or their interpretation of evidence that's presented, all she was able to do was respond to their interpretation as opposed to actively pursuing it and appealing it, correct?
That's correct. I think one concern the department has, though, is that DCS is the entity that the legislature has empowered and required to investigate exactly these types of claims. And the department did its job here when those issues were raised. If we are going to allow private parties to hire investigators to follow around relative placements, what's to stop that from turning on its head and a parent or another relative hiring a private investigator to follow a foster placement home and find out where the children are placed? This is a serious intrusion into the department's mandatory and legislatively recognized duties to ensure these children's safety. And so it is her job, her duty as a mandatory reporter to raise those issues, and it is the department's job to investigate them. And if she feels that was done inappropriately, there's an ombudsman. She could go to the legislature. She could do any number of things, but intervening in these particular children's dependency isn't something that she's shown was necessary. She did present the information she wanted to present to the court, and the court made a decision that she doesn't agree with. And
I'm a little confused by why the department would be so offended that someone else wanted to help out in investigating safety issues.
helping out is one thing, and the department appreciates her raising those concerns. As I understand it, some of the concerns were addressed. I don't know if the uncle had been living in the home and they asked him to leave. I'm not sure. I just recall seeing in a report that the issues were addressed. So it may be that some of her concerns did raise concerns for the department, and they took action on that. The issue is that then once the department took that action and the court determined that the placement remained safe, she continues to try to disrupt that placement when the children are in need of permanency.
And I guess that's where you lose me a little bit when you say the court determined. But there wasn't an evidentiary hearing on this. It seems to me the court determines when the court hears evidence on something. The court simply relied on DCS's investigative report.
There was
I mean, there was a placement hearing, but that was back in December.
Right.
And all of this activity happened long after that, correct?
And the court continued to have review hearings during that time, at which point these issues could be addressed.
We call them hearings, but
Well, and the parties...
like status conferences, right?
Sure, but the rule provides for an evidentiary hearing if a party requests one. And here, as I mentioned, the court had appointed the children and guardian ad litem, who had been very active throughout this case on the children's behalf, and initially vehemently supported their continued placement with Ms. Jones.
Counsel, you just said the statutes allow for a hearing if a party requests one.
Correct.
So Ms. Jones couldn't request one.
No, but the children's guardian ad litem could, if she felt that Ms. Jones' concerns rose to the level of the need for an evidentiary hearing.
So there's a secondary judge, really. Not only do you have Judge Anderson sitting on the case, but you've got Judge Guardian ad litem deciding whether or not she's going to proffer anything to the other judge.
The other issue is that she did file a motion to intervene. That's her first step. And had that been granted, and she indicated in her motion to intervene that what she wanted to do was present evidence regarding the children's placement. So she had, in effect, requested an evidentiary hearing, but the threshold matter is that she needed to be a party before she could do so. And she did not demonstrate to Judge Anderson that her interests in the case outweighed those of the existing parties to the extent that she needed to be made a party to the proceedings. I see that my time is up. Does the court have any further questions?
Thank you.
Thank you.
Thank you, Your Honors. I want to thank my friend, the lawyer for DCS. I think she has brought to the court's attention a very important fact, which was confirmed also by the GAL in her statement in the transcript that the court has, and that is that Jennifer Jones was an incredible foster mother. Why then were these children torn from her after they had bonded with her for almost 2 years of their young lives and placed with an aunt, where an uncle at one time was living there, still has access there? There was good evidence that he was sexually abusing the child. He has been convicted of drug and of gun convictions, where the investigator observed her leave the house, sit in a car and smoke marijuana while the children were left alone. It wasn't just a matter of not answering the bell, the doorbell. The investigator had seen her leave and leave the children alone in the house. All these dangerous concerns. Why were the children torn? I think there are two important reasons that we need to address very directly. The first one is the judge did not understand the statute that he was entrusted with enforcing. He thought that the aunt had a statutory preference over the foster mother. The fact is, the aunt does not have a statutory preference over the foster mother, and that this is what I described in my reply brief as an urban myth that is so prevalent that the legislature added unnecessary language to the legislation.
Well, that'll be litigated in the adoption, right?
Yes, Your Honor, but the placement is a very important part of the adoption.
But we're where we are now.
Yes, Your Honor, but we could contest the placement right now as a party.
If you were
if we intervene, and that could very well affect the result of the adoption. And so this whole thing, and this is a misunderstanding that is so common that my friend, the attorney for DCS, just said that Jennifer Jones is a legal stranger. A legal stranger. She knows these children better than anyone in the world does. And they are bonded to her. And there are both federal and state statutes based on the psychological reality that after 15 months, the bonding of the children to the foster parents is so strong that they should not be terminated unless the parents have been awarded before the 15 months or there's a specific reason set forth in writing. She is not a legal stranger. She knows the children better than anybody else. And the legislature, to emphasize her equality with everyone but the parents and grandparents, added unnecessary language to the statute because they were concerned about this very myth. The second reason, which I addressed in my opening, but there are a few more things to say about it, is the violation of the statute pertaining to holding people's race against them. She said DCS is not bound by the actions of one particular case manager. But they took that position, and it played a very prominent role in the judge's decision because it's not even a 2-page motion, and it's a 1-page attachment to the motion, and that's a prominent part of the presentation to the judge, which my client never saw and wasn't present for because as a mere participant she didn't have a right to notice, and she didn't have a right to see the motion that they have filed. We didn't see it until we got the response and read their appendix. She also said that the other reason for the change in placement was to try to keep the child with somebody in the family. And that reflects the same misunderstanding that the judge had. The legislature has said there is no preference to keeping the child within the family as opposed to the foster parent with whom they've bonded, who has a major role in the child's lives, unless you're talking about parents or grandparents. But in the case of an aunt, there is no such preference. And that misunderstanding was in the motion, and those were only two reasons. That misunderstanding and the illegal racial consideration were the only reasons given to the judge, but my client had no notice and didn't know about it. And the judge, in the transcript Your Honors have, showed the same misunderstanding about the statute, that the distant family members have preference over the foster mother, which they do not have. With respect to whether a termination precedes an adoption, when we argued the stay to Your Honors, I think everyone agreed that a stay of the adoption was going to do no harm because they were going to wait till after the termination and also after certifications and so on. Counsel said that this case would be consolidated before Judge Anderson. Judge Anderson has barred my client when she was a participant and had a statutory right to attend from his courtroom. If he felt he could do that with a participant in violation of her statutory rights as a participant, he would feel he could do that if she were a party. And I think the fact that it would be consolidated is an important reason to give her the status of an intervener so she can develop the facts and not be subject to being excluded from all of that information. Now, counsel for DCS says, well, DCS, it's sufficient that DCS does its job. If they take a position, that's the end of the story, and nobody else needs to have a voice. In fact, I think you could hear the fact that DCS does not like to be challenged. They feel this is their area, and nobody should be able to contradict them. So you have a situation where DCS and the GAL agree with each other, and they say, well, that's the end of the story. The two of us agree, the judge has to do what we want. The foster mother, who is desperately anxious for these children in the hands of the aunt who did so many things that showed she wasn't, dirty diapers and hunger and not giving them asthma medicine that the kids needed, who had bad asthma, and then an uncle having access to the house who sexually molests them and is criminally violated. All of these understandable anxieties that the foster mother has, the same as a biological mother would have. She has those same fears that any of us would have for our own children. And she's being told that she's a legal stranger and she has no right to give her side to the judge. So if DCS and the GAL agree with each other, that's it. No adversary proceeding. And that gets to the fundamental point that we're making in this whole special action. We are not a continental country. The judge in this case, we gave the court 3 examples from transcripts where the judge cut her off. I don't want to hear from you. I don't want to have to hear from her. She didn't even have the minuscule rights that a participant is supposed to have. And then he said, I don't need a party to contest this. I can investigate DCS myself. Well, that's what a continental judge does. But in our system, we have an adversary proceeding. And here you had what I described in my reply as the equivalent of a basketball game with one team on the court. And, when there's nobody against you, it's easy to make your shots. But that's not our system. We should have been able to be a participant. We should have been able to contest. We should be able to bring the facts, which is one of the factors the Supreme Court set forth, bring the facts to the judge so he can determine the best interests of the child. And we should have been entitled to get notice before there was an order barring us for the courtroom and reporting us for criminal and ethical misconduct. We should have had a chance to respond to that. So fundamental to all of this are the interests of the child and the adversary system, which have been completely neglected in this Kafkaesque proceeding that we had.
Thank you, counsel.
Thank you, Your Honor.
All right, we are going to take this matter under advisement at this time. We will be issuing our decision in due course. Counsel, we always appreciate the argument. Thank you for giving it to us.